Welcome. My name is Jason Thomas. On behalf of Deborah Buford, Manager of Employee Accountability here at the U.S. Office of Personnel Management, I am pleased to open this roundtable and introduce our speaker. Our office presents roundtables in support of our ongoing effort to bring relevant and reliable developmental opportunities to federal sector employee and labor relations practitioners. It gives me great pleasure to welcome you to today's roundtable entitled MSPB Case Law Update, Lessons Learned from the Most Influential Decisions. Today's presentation will provide an overview of the many responsibilities of the Merit Systems Protection Board, as well as an update and examination of significant federal case law. The discussion will encompass the most influential decisions that impact adverse and performance-based actions, appeal rights, and other matters relevant to the employee relations community. We encourage everyone to make the most of this roundtable, including asking questions of our presenter. You may do so by sending an email to employeeaccountability@opm.gov. We will do our best to field as many questions as possible. Please note that shortly following the presentation, everyone who registered will receive a hyperlink to an online evaluation form courtesy of surveymonkey.com. Simply click the link, follow the instructions, and your valuable instant feedback will be sent back to us. Your feedback is important to us and helps us plan future roundtables. Michael Bogdano currently serves as the Senior Legal Liaison at the Merit Systems Protection Board between headquarters and the MSPB's 8 regional and field offices. Mike is a certified mediator in the MSPB's Mediation Appeals Program and has authored several law review articles. He is a frequent presenter on MSPB case law conferences. We are delighted to have Mike as our presenter today to share his expertise in this subject area. Please join me in welcoming Mr. Michael Bogdano.
Thank you, Jason, and thank you all for listening in this morning or this afternoon, depending on where you are. I am Michael Bogdano, as Jason said, and I will be your entertainment for the next 90 minutes, assuming you have a very loose definition of that word, and excuse me, that you are easily amused. It's my understanding, because I'm just looking at my PowerPoint here, it's my understanding that you guys will be seeing both the PowerPoint and me. So as they used to say in the days of television, don't adjust your sets. You'll be seeing some funny-looking old guy, and that'll be me. I was asked to do sort of a schizophrenic presentation here today by talking about board jurisdiction, as well as some of the more recent significant decisions. So let's launch into that. What I wanted to do was to put out a couple of slides just to give those of you who aren't terribly familiar with the board a general view of what the board is and how it's set up and all of that. This picture, the map of our regional and field offices, shows you our geographic jurisdiction. When an appeal is filed, depending on where the employee worked, in most cases, that is the office to which he or she files the appeal is the one that has geographic jurisdiction over that area. In cases involving retirement, like OPM cases, we do it based on where the employee lives. Excuse me. As you can see, our San Francisco, the Western office, covers Hawaii and Alaska. It also covers the Pacific. We have our Washington office there covering, an area in the continental U.S., but they also cover, excuse me, Europe, South America, the Middle East, all of that. So we are, worldwide, and just as a matter of course, in pretty much every case that is overseas, we do those by video conference. If we are holding a hearing, we don't send people over to those kinds of places. This just gives you an idea of how the board is organized, and to prove for any of you who may have had your doubts that, yes, in fact, the MSPB is organized, for what it's worth. We are there on the right end, the regional operations and regional and field structure listed below that. So, what is MSPB and what does it do? As this indicates, there are two main functions at the board. The first is adjudication and the second is studies. Both of those are called for in the statute that set up the board, and so I want to concentrate obviously on adjudication, but mention studies as well because it is a very helpful kind of thing to know about. As far as adjudication, 5 U.S.C. Section 1204 sets out that the board will hear, adjudicate, or provide for the hearing or adjudication of all matters within its jurisdiction. And it basically gives us jurisdiction under law, rule, or regulation. Law, of course, matters set by Congress. Regulation are those regulations passed by OPM. So those are the extent of our jurisdiction. We don't have the authority to extend our jurisdiction beyond what Congress and OPM has given us. But we do, as the second paragraph indicates, Section 1204B, we have all of the things that are needed to develop a record in order to make a good decision, all of the authorities. We administer oaths, examine witnesses, take depositions, receive evidence. We can issue subpoenas. We also require responses to written interrogatories at times. In other words, we have the authority to carry out the function that Congress gave us. The board's procedures, as I'm sure you all know, are in 5 CFR Part 1201 for the main part of our jurisdiction. Part 1208 is our VOA and USERA jurisdiction. 1209 is the whistleblower jurisdiction, and 1210 is now largely defunct. It was related to the Department of Veterans Affairs SES cases when those kinds of cases were being heard. As you'll hear a little later, they're not being heard at this point. But moving on from adjudication, the studies function and the review of OPM regulations is one that is very significant and that I think a lot of people don't give sufficient credit to, and they don't pay a sufficient amount of attention to it. The studies that the board's Office of Policy and Evaluation do relate to issues that are really very on point for anybody involved in federal civil service. The issues that they work on are matters that directly relate to appeals. I recently saw a draft study of the supervisory probationary period, how it can be used, how it can be improved, you know, what the situation is with it. In other words, they do studies on matters that I think if you are ever stuck on an issue, you can perhaps find a study that was done that will help you out and give you some really good ideas, even if you're talking about an adjudicatory kind of issue. All of those studies, as well as papers that the Office of Policy and Evaluation writes, issues of merit and things of those sort, are found on the board's website. So I definitely recommend that if you have any interest in studying up on what kinds of studies the board has done, that you look at that. The board's mission, I put here simply, you know, to let you know that the board takes its mission very seriously. What we try to do is, as this suggests, protect the merit system's principles and try to get agencies to avoid prohibited personnel practices. And of course, all of our goals, agency-wide goals, are based on that. So they all hook into that and try to assure that we meet that goal. The vision is just our aspirational goal, of course, but the board does take this very seriously. When we're dealing with jurisdiction, there are two types of jurisdiction. First, there's original jurisdiction, and what that tends to mean is that the board is looking at something that hasn't specifically been processed through an agency in most cases. The original jurisdiction covers the Hatch Act cases, which are those dealing with political activities, corrective action and disciplinary action cases brought by OSC, the Office of Special Counsel, against somebody who is accused of making a prohibited personnel practice, or in favor of an employee who is seeking relief from a prohibited personnel practice. In our original jurisdiction, we have the authority to grant a stay requested by the special counsel of a personnel action that is allegedly taken because of whistleblowing or other kinds of PPPs, requests for review of regulations issued by OPM. The board reviews those as long as the criteria in our regulations are met. And the board also gives informal hearings in cases involving proposed performance-based removals of employees in the senior executive service. As I said, the original jurisdiction cases are processed at board headquarters, and they deal with the kinds of matters that you've just heard, which, unlike our appellate jurisdiction cases, don't generally go through an agency. The special counsel cases and the cases against administrative law judges that we hear, all of those are heard by an administrative law judge, as opposed to all of our appellate cases, which are heard by an administrative judge. Right now, the board does not have an administrative law judge. We contract with other agencies, though, to provide administrative law judges in order to hear those kinds of cases. They're set up frequently very much like a board appellate jurisdiction case. That is, the administrative law judge issues an initial decision. In most of these cases, they're subject to filing a petition for review, and otherwise the initial decision becomes final. So it's really just the subject matter more than the the process that is different when you're dealing with original jurisdiction cases. Appellate jurisdiction cases, these are the very large bulk of the cases that we hear. When the board hears a case under its appellate jurisdiction, it reviews an agency's decision in almost every action. Usually it's an employing agency, of course, but in the case of OPM, in its retirement cases, we hear determinations that they make not as to their own employees, not solely as to their own employees, certainly, but as to any retiree. In cases like IRA appeals and some VOA and USERA cases, an applicant may have a right of appeal to the board, and we hear those kinds of cases as well. So it's a fairly broad range of issues that we can hear. Most of them, though, that you guys would be interested in are really the standard agency makes a decision that is somewhat adverse to the appellant, depending on your definition of the term, and that matter then gets appealed to the board, and that's part of our appellate jurisdiction. As this indicates, the straightforward appeal to MSPB can sometimes get very complicated particularly when, along with whatever the matter is that's being appealed, an employee claims discrimination under B1, race, sex, national origin, those kinds of things, raises a claim under VOA, that their veterans' preference rights were denied, an employee who is subject to a collective bargaining agreement, you have to figure that in, and if the employee is raising a claim of whistleblower retaliation, all of that complicates a basic case, and I don't mean necessarily the substance of it, but just the manner in which it gets to the board. The board requires in all cases where an agency makes an appealable decision that the agency give the employee a notice of the kinds of appeal rights he might have, not just to the board, but whether he has a right to go through the grievance system, whether he or she has the right to go file a discrimination complaint, informs the employee of any exhaustion requirement that he or she may have, for instance, with the Department of Labor in a VOA case or with the Office of Special Counsel in an IRA appeal. And of course, with discrimination cases, we, as the board, get to hold the hearing in every mixed case, whether an employee has chosen to go to his agency to file a discrimination complaint or not, whether they've simply raised it to us. We hold the hearing in all of those cases, not the EEOC, but from a board decision in a mixed case, the employee can seek an EEOC redetermination on the issue of discrimination. And when that happens, if EEOC agrees with us, then the case leaves the administrative forum. If they disagree, they can send the case back. We get to agree or disagree and send the case back. And there's this little tennis match that goes on that can lead to what's called a special panel, of which I believe there have only been 8 in the many years that the board has been in existence. But in any event, my point in putting up this slide is simply to say that although it sounds pretty straightforward, as those of you who write advance notices and decisions for an agency are aware, it ultimately ends up being considerably more complicated depending on the issues being raised. This is This is just a chart of the types of jurisdiction that the board, types of actions that the board has jurisdiction over. In the column that's on the left side, those are the basic appellate jurisdiction kinds of cases that we're all used to seeing: adverse actions, performance actions, reductions in force, and all of those. In each of these, one thing about them is that an appellant can raise an affirmative defense. An affirmative defense alone does not give the board jurisdiction over any matter that isn't appealable to the board, but it can be raised in connection with any matter that is appealable to the board. In contrast, the group of cases on the right, the individual right of actions, VOA and USERRA cases, do not allow for an affirmative defense to be raised. And why is that? It's because the statute that gives us authority over each one of these gives us authority over only those and doesn't go through the 7701 statute cited there on the left that would, the 7701 was cited in the earlier panel. It doesn't give us jurisdiction through a right to file such an affirmative defense. Plus, because each of these statutes gives us jurisdiction in over a specific kind of claim, a claim that the agency took an action that it shouldn't have taken or didn't take an action that it did, because I am a veteran or because of my veteran in violation of my veterans' preference rights or because I blew the whistle, it would be kind of inconsistent with that kind of logic to also bring a discrimination complaint and say, oh yeah, and they also did it because, I am an old man or whatever it is. So that's just the big difference between the kinds of appeals that we hear in our appellate jurisdiction. And these are the affirmative defenses. They're not anything unexpected, obviously harmful error, prohibited personnel practices, and not in accordance with law. And at the bottom of that, there's a definition of each one of those. Not in accordance with law is really the one that people have a harder time figuring out. It just means that there's no legal authority for the action. And that Stephen case cited there is the one that is really the lead case on that issue. It's been, 20-some years since it was decided, but it is still the lead case. When you're looking at a case to determine the board's jurisdiction, just like in a court proceeding, you have to have jurisdiction over the action, and you also have to have jurisdiction over the person. In order to determine whether there's jurisdiction over the person, you check out these kinds of things. Does the employee work in the competitive service? Does he work in the accepted service, the postal service, or the foreign service? Does he have some other kind of appointment? Does he work for Congress or for a legislative agency, perhaps the judicial branch? Neither of those do we have jurisdiction over, but there's always some sort of some kinds of situations in which the basic rule doesn't apply, but that is certainly a good rule as a matter of course to follow. Also, of course, is the employee a veteran? Does he have veterans preference eligibility? Is he a non-preference eligible? Or is he a probationer? Of course, each of those is the kinds of thing that you have to determine before you know whether we have jurisdiction over the person. In connection with adverse actions and several of the other areas that are listed on that previous slide, we have to determine if the appellant is an employee pursuant to 7511, 5 U.S.C. 7511, because it is only an employee as defined by that statute that has that is authorized to file an appeal with the board. I put down the McCormick versus Department of the Air Force case in this slide because it was at the time, right now when you look at it, it looks harmless. It basically quotes what 7511 says, but at the time that it was issued, it was like a real game changer. Up until McCormick, as you see, under subsection A, subsection B, and subsection C, there are small Roman numerals 1 and 2 separated in each instance by the word or. Up until McCormick in 2002, the board and the Civil Service Commission for years before it had interpreted the or to mean and. That, in other words, you had to qualify under both subsections. But in this decision, the court said, nope, or means or, and that's why this is the or means or case. And like I say, it hit like a ton of bricks, because even in the decision, the court basically acknowledged that, yeah, Congress intended to continue in the Civil Service Reform Act, when it gave that authority to the board, it intended to continue the rule that the Civil Service Commission had previously been using, but they used the word "or," and the court found, in that case, we're holding them to what that plain meaning of the word is, and so ever since then, it's been a settled issue, and you can rely on the word "or" in this instance to mean "or," although there's a case later on where you will hear that you can't rely on the word "or" to mean "or," but we'll get to that in a bit. A couple of slides on what's coming and what's new and all of this. The board is a bipartisan board made up of 3 presidentially appointed members who are each appointed for 7-year terms. However, and each of those, I should say, can hold over for an additional year or until sometime during that year a successor is appointed. At this point, we only have 1 board member. And as great as he is only one person and does not constitute a quorum. Our chairman position has been vacant since the beginning of January of this year. The vice chairmanship had been vacant since March of 2015, and the member position was filled, but the board member was elevated to become the vice chairman just a couple of months ago. So we have 1 board member. And what that means is that for purposes of the regions, everything is going on as it usually does. The judges are still pumping out decisions, hearing cases, and all of that. But the board, because it lacks a quorum, cannot issue decisions. So at this point, we warn the parties when we issue an initial decision that we don't know when that's going to end. If they want to file a petition for review, they're certainly welcome to do that, but it can't be decided by the board quite yet. So, it's interesting because when I do the cases that I'll be getting to in a little bit, the significant cases of the last year or two, depending on your viewpoint, which party you're supporting, the decisions are kind of like a good news, bad news kind of thing. And this year, I think that's particularly true. The bad news in this particular instance is because there's no quorum at the board cannot issue any decisions. But the good news is there's no quorum at the board, so the board can't issue any decisions. And depending on your point of view, you can choose to think that's great or not. But that is the way it's working at the moment. The next section just talks about a couple of changes that had been made. There's now a new appeal right to the board when an agency makes a notation in an employee's OPF about the results of an investigation where he or she resigned before the investigation was complete. The agency is now required to put a notation in their OPF, and that becomes particularly important because another statutory section says before a federal agency hires a former federal employee, they have to check his OPF for those kinds of notations. And they've given an appeal right to the board from that. There's also a proposed, now it's a Senate bill on the floor of the Senate that also gives us additional jurisdiction. I didn't put it in here because it was just sent to the Senate a couple of days ago, but it gives us jurisdiction when an agency takes an action against an employee that is a suspension for more than 2 weeks. The agency then would be barred under this statute from giving the employee a bonus for the next 5 years, and if it had given the employee a bonus within the last year, they take it back. And from both of those actions, there's a right of appeal to the board. We also, as the slide says, we receive jurisdiction under the National Defense Authorization Act to hear adverse action appeals from technicians in the National Guard, a group that we never had specific authority over. We had jurisdiction, in fact, but we had no authority to carry out most of our jurisdiction, any kind of an order, and now this statute has given us that. Moving on, there are a number, as I'm sure you're as well aware as I, of considerations going through Congress about changes to the appeal format, how long an employee gets to respond to an adverse action before the agency, a proposed adverse action, how long the appeal right gets to take. There's a plan to simplify charging, which is consistently a problem, the wording of charges, all of these things. I mean, so my point here is simply to say that all of this stuff is in flux right now, and particularly because there is no quorum of the board, and when there will be two members about whom we know nothing at this point. So everything is sort of up in the air. So, you can take what I tell you with a grain of salt as to how useful it's going to be in the future, but it's the best information we have right now. I put the Lucia and Bandemir cases, that next paragraph, in here. Obviously, we are not the SEC, but the issue in that set of cases is what authority an ALJ in those cases has to issue a decision when they're not considered agency officers, when they're simply considered, I hate the term, inferior officers or simply employees. In one of those cases, the court said they don't have the authority to issue those kinds of decisions. And another, they said they did. And so both cases are now being reconsidered by their courts. And if they still end up split, I think we'll be seeing that at the Supreme Court very soon. There's now also a case in the 10th Circuit, which issued the Bandemir decision, in which somebody has in fact challenged our MSPB's AJ's authority to issue decisions in board cases. So we'll be seeing a decision from them as well. Another coming attraction is one that you probably read about in the papers. In the Perry case, Perry versus MSPB, the court was asked to follow up, the Supreme Court was asked to follow up on its decision in the Kleckner case, Kleckner, I'm sorry, I don't know how to pronounce the name, versus Solis, in which it held that in a mixed case, if the board does not decide the main issue because it dismisses the case on a procedural reason such as untimeliness, that constituted still a mixed case and would be heard on appeal from the board by a district court, not the Court of Appeals for the Federal Circuit. Ever since Kleckner, of course, we've been following that decision, but there's one kind of exception we've made to that, and the Federal Circuit has agreed, which is because we define a mixed case as a case over which we have jurisdiction and there's an issue of discrimination raised, in those cases in which we find that we do not have jurisdiction over the case and therefore don't reach the issue of discrimination, we consider those not mixed, and we therefore say that the employee's appeal right is to the Federal Circuit. In the Perry case, An appellant challenged that, wanted to go through the district court, and was denied, and brought the case to the Supreme Court. And so now, if you've heard the argument that went on there, it was, I should say, the newest justice's first case that he heard. So as a federal employee, you will have a place in his heart forever. Listening to the argument, and you can do that, by the way, if you listen to it, you'll hear that the court found the statute pretty confusing. And in a way, it's kind of nice. I mean, it's not good to have a confusing statute, but it's kind of nice because to the extent that the courts have given the impression that perhaps board law is not really as challenging as some others kinds of law, this pretty much sets that on end. So that's one case that you definitely should be looking out for. And the one that's already been decided that addresses some of the same issues that I've just talked about is Helman versus Department of Veterans Affairs. This is a case that arose from the VA SES statute that I said is Part 1210 of our regulations. This was a statute that was passed in reaction to what Congress saw as the wait time scandals at VA hospitals for treatment of veterans. And in that statute, what they said was they cut down the time limit that the employee had to respond to the agency, and in fact, they cut it out, but VA put it back in. And then they said, number one, when you appeal to the board, you have 21 days to decide the case under 5 U.S.C. 7701, meaning you get the right to discovery, meaning you get the right to a hearing, meaning you get all of the procedural niceties that our normal process allows, all condensed into 21 days. The decision also said the board members cannot hear an appeal from that board decision, from that AJ's decision. And it then said as well that that was it. The AJ's decision was it. Couldn't go to court from it. And last, they said, if the AJ did not issue a decision within 21 days, the decision of the agency became final. So Sharon Helman, who had been fired from a job out in Arizona, filed this appeal with the board. The AJ issued a decision upholding the action. She then filed a petition for review. The board said, sorry, we don't have authority to look it over. She then went to court. And in this decision, the court said, first of all, yeah, of course, the statute says we don't have authority to consider this case, but we have authority because you've raised constitutional issues, and we have the authority to review colorable constitutional claims. So they did look it over. They found that vesting final decision-making authority in our AJs was unconstitutional, that it was a violation of that appointments clause. That issue that I said in Bandemir and Lucia is pending. They said that it was also unconstitutional to require that that the decision of the agency becomes final if it wasn't decided by the AJ within 21 days. And they specifically said they did not decide whether AJs in general would have the authority to decide a case in the appellate jurisdiction of the board. But in this instance, the decisions were being made by the director of the agency, the head of the agency, and they said that an employee as opposed to an officer, didn't have the authority to countermand his instruction. So what the court was left with was sort of half of a statute, and they then went on and determined from the best evidence that they could find whether the Congress would have kept the statute in that sort of half form, or whether they would have preferred not to have a statute at all if they knew that those provisions were unconstitutional. And they determined that Congress would have preferred to go ahead with, just the limited review by the agency before the appeal to the board. And so they sent the case back to the board, and they said, board, consider the PFR that the appellant had filed. And then they've sort of suggested that on the merits of it, they wouldn't have jurisdiction, but then again, that wouldn't really square with their total determination. So exactly what happens after the board, number one, gets a quorum, and number two, decides this case, we don't know. We'll see if they go back to the court, what the court has to say. All right, so now, finally, we're turning to some board decisions. The first area that I wanted to mention was whistleblower protection, which is always a big issue. It's a growing area for the board. We get an awful lot of whistleblower cases, and as I suggested, we keep getting more. This is just the provision of 2302b8 that talks about, that is the basis of a lot of the statute, well, of the protection that is provided by the Whistleblower Protection Act. As you can see, if you read through it, it talks about disclosures, and disclosures are what we had always been considering as whistleblowing. We hadn't really gone beyond that because that's what the statute said. When the WPEA, the Whistleblower Protection Enhancement Act, was passed, it pulled in 2302b9, most aspects of it, to allow an IRA appeal to be filed in connection with certain activities that an employee engaged in. And therefore, these kinds of activities that are listed there also are now considered to be whistleblowing, and as I say, an employee can file a whistleblower appeal on those kinds of actions. You can think back to those requirements, or look back when you have a chance after this at those sections to sort of get a better handle on these next few cases that I wanted to mention. In Corthell, the board had previously, under 2302b8, that is the disclosure statute, talked about how even if you had not blown the whistle, if the agency perceived, wrongly or correctly, that you had done so, you are protected from retaliation for that. So the issue that arose in Corthell is somebody who took an action protected by B9, who, in this case, he cooperated with an IG. Was that activity protected if the agency just perceived, but he didn't really cooperate with the IG? And the board decided, yes, it was protected. So now there's a perceived whistleblower rule under both B8 and B9. This case, the Salerno case, I just put in, the facts of it are not as significant as the reason that I wanted to put it in, which is that what this shows is that just because you can fit a particular disclosure into one section of 2302b8 and find, well, it's not protected by that, so therefore the appellant is out of luck. In fact, the same disclosure can, in fact, fit in various different sections of 2302B8 and B9. For instance, in this case, the appellant made a disclosure that the agency's law enforcement security system violated law or was not up to the legal requirements of the law, and he made that disclosure to OSC. When he then later on perceived that he was being retaliated against for making that disclosure, he filed an appeal claiming retaliation for having made the disclosure. And the board was able to say, well, it could be a disclosure of information that the employer reasonably believes violates a law under B8A, could also be under B8B, any disclosure to the special counsel. And in both instances, though, it found that the disclosure wasn't sufficient to constitute a non-frivolous allegation to meet the jurisdictional standard, and therefore neither of those was of any use to the appellant. But the board then went on and said, but wait a second there, under 2302B9C, which is a disclosure to the Office of Special Counsel in accordance with applicable provisions of law, in this instance, what the appellant was suggesting actually met that standard, or at least he made a non-frivolous allegation that it did. And therefore, the board found that it was potentially protected under that provision and sent the case back to the board, to the AJ, excuse me. And so the point is just that a single disclosure can be protected under more than one whistleblower provision. And the last paragraph has become significant in a bunch of cases. In the Salerno case, as I said, the appellant made a disclosure to OSC, and then he also, of course, had to file a complaint with OSC when he suffered what he thought was retaliation. And the board, in both of those instances, he came to the board and said, yeah, you know, I don't like the job that OSC is doing. They didn't really check out my disclosure. They didn't give the full review to my complaint. And therefore, board, you should do something about that. And the board found that it lacks authority to review OSC's investigation, and it has no authority to, you know, countermand OSC's procedural, the process that OSC went through. Interestingly, the court, several weeks after this decision was issued a non-precedential decision in which they agreed that that was true, but so far I haven't seen a precedential decision saying so. Let's see, in the next case, the Rainey case, I have to apologize to you. I don't know exactly what happened. When I updated the handouts that you guys have, the Federal Circuit and the MSPB handout, the last updates that I did, of course, changed some of the pagination in the Federal Circuit handout, and I changed it on the slides here as well. And then apparently I sent the wrong version to OPM, so the cases, the page sites on some of these Federal Circuit cases are incorrect. So rather than page 16 in Rainey, it was actually page 20. But if you look within the next 1 to 4 pages in the handouts, you'll see that those are that's where those cases exist. This case really is a case that just stands for, as in McCormick, or means or. In Rainey, the law means law. In an older case, McLean versus Department of DHS, excuse me, the Department of Homeland Security, the issue had been whether the appellant who was alleged to have violated the rules concerning sensitive security information, whether that constituted something that was specifically prohibited by law from being disclosed. In other words, you cannot disclose SSI, sensitive security information, that is because the regulations that Department of Transportation issued prohibit it. In that particular case, it went all the way to the Supreme Court, and the Supreme Court said, well, this says specifically prohibited by law. This SSI is specifically prohibited by a regulation, and granted, the law gives the regulation force. It is nonetheless the regulation that controlled, and therefore he did not violate a law by disclosing this information. In this instance, the court, applied that kind of logic to a different provision of the law, which is taking a personnel action for refusing an order that requires the individual to violate a law. And applying that same logic, the court found in this case, it says law, it means law. The appellant said, wait a second, I did not follow the supervisor's requirement because it would have required that I violate the federal acquisition regulations, and those are majorly important kind of regulations, and so close enough. And the court said, no, sorry, it says law, it means law. And they were also able to point out that although when the phrase is violate law, you could sort of give that a broader interpretation because you could think of a regulation as a law in the broader sense, but because the statute in this instance referred to a law, the court found that it was most likely intended to mean indeed just a law. So it sort of parses out the language of the statute, and that's what statutory interpretation is all about. Excuse me. So it's a significant case from the standpoint of holding of deciding the definition of that term in that particular statute, and both of them are now defined in the same manner. In this case, the Cahill case, really the lesson of this case is deny, deny, deny. What the court found was that whether the appellant made a non-frivolous allegation depends on how his allegation would have been understood in context, especially by the responding agency. Now, the judge and the board found the appellant had not made a non-frivolous allegation that anybody associated with whatever the retaliatory action was knew about his disclosure. In the court decision, however, the court noted the agency didn't argue that they didn't know about it, and because they kept silent, we're going to find against them. The court obviously had additional reasoning, and that was by not arguing that point, the agency didn't put the appellant on notice that he had to argue that indeed the agency did know about it. So the point is just that if you are the agency, you have to address each of the provisions that make up the appellant's case in order to at least indicate whether you are or you're not arguing against them. In Kerrigan, Mr. Kerrigan was a guy who had a very contentious relationship with the OWCP, the Office of Workers' Compensation Programs. He'd been getting OWCP payments for a number of years. Over the years, they'd been trying to get him off of that. They'd been trying to send him for rehab. They tried to send him to vocational training. And ultimately, they ended up cutting off his benefits, terminating his benefits, based on his contentious relationship with OWCP. He filed a whistleblower appeal to the board, and he said, look, board, see, the agency cut off my benefits because of my whistleblowing about their lousy processing of my appeal. And the board said, sorry, the statute number 1 says we have no authority to review an OWCP determination, and in order for us to find out whether indeed it was retaliation, we'd have to look at the merits of the termination of benefits. We can't do that. But it went on then and basically found, but we don't see very much merit to your case in any event. So he went to the court, and the court said, yeah, the statute does say that you can't review decisions of OWCP, but that isn't really what it means. It just means you can't review some of them, and we can review all of them. And it's another instance, like in Helman, where the court was not deterred by the fact that the statute says that there's no review. In the law, there is a presumption of reviewability, I should say, and the court was exercising it here. But the statute did, the court rather, did look over the merits and ultimately agreed that there was no indication that it was more likely, they said, that OWCP cut off his benefits because of the fact that they had tried to get him to address those kinds of issues that they had said were lacking, and he hadn't done it. The clear and convincing evidence case is the Miller case, and the reason that this case is here is just for those of you who aren't familiar with the board process. The appellant in an IRA appeal, a whistleblower case, the appellant has the burden of making a prima facie case, a non-frivolous allegation of that his whistleblowing was a contributing factor to some personnel action that the agency took in retaliation for it. If he makes a non-frivolous allegation, then he's entitled to a hearing. After the hearing, at the hearing, I should say, if he then has the same burden to prove each of those things by preponderant evidence. If he does that, then he wins unless the agency comes up with clear and convincing evidence that it would have taken the same action despite the fact of his whistleblowing. And here, what is significant is not so much the facts back and forth, but the fact that the court applied the what's called the Carr test to determine how strong the agency's evidence was. Factor 1 being the strength of the agency's evidence, Factor 2 being any motive that it had to retaliate, and Factor 3 being whether its treatment of similarly situated whistleblowers was similar to the kind of treatment it gave the appellant. Normally, in that Factor 3, if there's no other comparator or just a very small group of comparators, the court says, well, there are not enough people here to determine the value of this factor, so it's just neutral. In this instance, however, they went on to say the agency compared him to 4 other people who were in his very much the same kind of position that he was in, and the court said, well, that's just too small a group. And so, but then rather than find it simply neutral, they said, we could find this neutral, but because it was such a narrow view, we'll find that the fact that is that the agency has access to all of its records, we'll find that it cuts slightly against the agency. So I think the point on this one, aside from sort of establishing new law on that factor 3, is that if you're an agency, you may have to do more than minimal kind of looking in order to determine the group of comparators that will make for a strong enough case to meet the clear and convincing evidence standard. That is the toughest standard to meet, and this case just illustrates that it can be very tough indeed. Moving along, the next area, there are a couple of cases on probationers. This one is, the first one, Lemaster, actually is a twofer on the word probation. The appellant was hired while he was under probation in a criminal case, and of course was hired on a probationary appointment in the civil service. The point of this case, though, is that the agency ended up terminating him during probation based on, they said, the failure, his failure to disclose the effect that his criminal probation would have on his ability to perform his civil service job. The board looked at the record, though, and said, wait a second, his probation officer had approved him to work. He or she had spoken with the agency, told them all of the terms of the probation, and the appellant himself admitted to the agency that he was on probation. And so really what the agency was doing was that it had a change of heart, if you will, according to what the board found, and just decided that it was not appropriate for him to be hired while he was under criminal probation. And therefore, it was a pre-appointment reason, and because you're entitled to certain procedures, that when it's a pre-appointment reason that you don't get, when it's a post-appointment reason, that was a problem in this particular case. So he was entitled to those kinds of processes. You don't get this a lot, but you do, in some cases, have to draw a pretty fine distinction between what is pre and what is post appointment kind of conduct. And in this case, the agency drew it too fine a line. Jurisdiction, not exact, well, on a probationer issue, in this case, the board was correcting a problem from 1984. In the accepted service, there was a case called Roden versus the Tennessee Valley Authority, which did justice in the particular case. The employee had received 5 consecutive temporary appointments, each for less than a year, separated by only a couple of days, each one of them, and he spent less than 9 months in the last of those 5. The board looked at it and said, well, the agency here is trying to screw around with what the law says. Clearly, they intended to keep him around for a relatively long period of time, so it was disingenuous to keep giving him these individual appointments. And so we're going to find that he meets the test to have appeal rights. Well, of course, that is very fair to the appellant in that particular case, but it set a very bad precedent. Finally, in the Wins decision, the board overruled that case, and now it goes with the current definition of current continuous service, which is the statutory term, and requires that in the same kind of situation, the employee would not have appeal rights. Moving on, another jurisdictional aspect is constructive actions. Here, a constructive suspension. And the reason that I put these two cases in was that they both involve what is alleged to be a constructive suspension that might, the board said, in fact, be a real suspension. and the board and the court, I should say. Thomas is the case that sets out the board's test for what is what makes for a constructive suspension. As the first paragraph says, the employee must have lacked a meaningful choice in the matter, and it was the agency's wrongful acts that deprived him of that choice. So it's an easy two-part test. If you find the employee basically was faced with a no-win situation and that it was the agency's action that caused that, if that action was wrongful, then he's been constructively suspended. Here, the appellant had allergies. Her doctor said she couldn't work at the workstation that she'd been assigned. The agency tried to send her to another one. Same deal, she couldn't work there. The agency said, okay, you can telework 2 days a week, and 3 days a week you have to take leave. The board found that she non-frivolously alleged that because the agency had gone against her doctor's orders by requiring her either to work in a place where she couldn't work with good health or to take leave, that constituted a non-frivolous allegation that she was suspended. The board went on, though, to find that she also claimed that this was an actual suspension. You can indeed be suspended even if you are on leave, if you have to use up your annual leave in order to do so. And so the board said, well, Mr. AJ, if you don't find jurisdiction on the basis of a constructive suspension, then check it out and see if it meets the requirements for being an actual suspension. In Rosario Fabregas, the Federal Circuit was faced with a sort of analogous kind of claim. The appellant had been absent because of depression. He said he'd returned to duty at one point. The agency said, great, come ahead, but before you do, give us medical proof that you're capable of returning to work. The appellant didn't do that, and the agency said, well, we're not waiting forever here, pal, but while you are getting that medical evidence, you can request leave until such time as you get it. The appellant then filed an appeal saying, when the agency told me I should request leave, that met the test for being an involuntary suspension, a constructive suspension. The board said, no, it didn't, because the agency had the right to request proof that you could, in fact, you were healthy enough to return to work. The court agreed with that, and it affirmed the dismissal of the case, but sort of like the other theory in Thomas, the case that was just before this, there was a dissent before the court, and that judge said, this actually is a facially involuntary suspension. They said, stay away, take leave, and that constitutes a suspension. But because that was just a dissent, that isn't the rule of the case. But it's interesting that in both cases involved a sort of fine distinction between what's actual and what's constructive. Again, the three cases that are here, listed here, involve drug testing issues. And it's interesting that there were three precedential decisions within about a year of each other that, talk about drug testing and also sort of bring forward the law on that. So that I will go through these relatively quickly so that I don't run over time. In Holton, the first case, the appellant was a crane operator, supervisor, and he was drug tested, as was his entire team, after a crane caused an accident while lifting a 60,000-pound load. You can imagine you don't want to be around when that happens. But the decision stands for the proposition number one, that a mandatory drug test is a Fourth Amendment search and seizure, and it has to be reasonable in order to pass constitutional muster. But as the quotation says, neither a warrant, probable cause, nor individual suspicion is essential in every case to prove reasonableness. So what kind of case don't you need that in? According to this decision, warrantless post-accident testing is appropriate basically when you work in an industry that is heavily regulated because of safety concerns. It's a very natural fit to say you do things that could really harm people. Therefore, whether you work in a testing designated position or not, whether the agency has probable cause or not, we are going to allow these kinds of positions to be drug tested, and the board approved the action in that particular case. The final line down there, the also line, is that there is no right to due process in accordance as to the decision to drug test an employee. So if you're in one of those positions, the agency can say, right now, go and get drug tested. It's not like you have any due process rights to, consult your lawyer and submit a response and things of that sort. The Forty case is the one that stands for the proposition that chain of custody has to be proven by the agency. If the agency doesn't do it, it can pretty well forget about the case. The appellant in this case stated that when he was drug tested, when he gave his specimen, the agency, the person who took the specimen, let him leave and actually called him back 10 minutes later and said, here's your specimen, sign it, to prove that it's actually yours. The appellant did so, but filed in his appeal and said, the chain of custody is broken here. I didn't know actually that I was signing that this was really my specimen. I mean, they could have done anything with it in 10 minutes. And he had the presence of mind also to have a hair follicle test done. That came back negative for cocaine. He, through his attorney, once an action was taken, said, give me a piece of that sample there so that I can have it drug tested separately. The agency agreed, but they found, as will any agency, an appellant who tries to do that in the future, that the rules of the agency that holds those, that makes the rules about urine sampling, the SAMHSA, does not allow any sample outside of its control. Therefore, it is not possible to drug test privately, and given the hair follicle test, given the break in the chain of custody, and given both parties' inability to have the sample tested again, the board found that the case was just not sufficient to prove for the agency, and the appellant won in that instance. Brune is an interesting case because as you know, there are a lot of states these days which allow medical marijuana. California is one of those. The appellant had been on a last chance settlement, and so a lot of this decision really talks about the last chance settlement. But the point I want to emphasize is that there's a doctrine called preemption, which means federal law always controls over state law if the two are not consistent with each other. The federal law still defines marijuana as a category, a Schedule I controlled substance, and despite the fact that the appellant was growing marijuana legally under California law because he was giving it to his wife to counteract the effects of her treatment for cancer, there's something called the California Compassionate Use Act. Nonetheless, that constitutes a violation of federal law, and so the appellant lost his job. So the point is just that simply because you work in a state that allows for medical marijuana, that doesn't mean that your job is safe. So take that for what it's worth. The lack of candor, there are two cases here, and again, they're not as important for the particular facts as they are to show that the board has tried to clarify what lack of candor is by setting out elements that will prove it. And when you read the next case, Farnioli, they say very directly, here are the two elements to prove lack of candor. Number one, the employee gave an incorrect or incomplete information, and number two, he did so knowingly. Sounds pretty straightforward, but then you get to Oleg, and they try to distinguish that from falsification, and they talk about intent to deceive, that there is an element of deception in lack of candor, but unlike in falsification, there's no requirement to prove intent to deceive. And they go through the factors that way. And I think if you're a lawyer, perhaps it makes a good bit of sense. If you're not, I think perhaps it's more confusing than anything. The fact is, it and many of these other cases, I think, are indicative of an attempt to clarify things that may work in some cases, but you still have to be, bottom line here, very careful in choosing your words if you're charging either falsification or lack of candor. There are some aspects of the charge of lack of candor that are very clear. You don't have to have an affirmative misrepresentation. And then there are some that are a little less clear. One way of avoiding that might be, depending on the circumstances, simply not labeling the charge. You have to consider all of those factors when you're deciding what kind of a charge to bring. The next issue is settlement. And this, for any of you who've tried to settle a case with the board in an IRA appeal or a probationer appeal or a USERA appeal or even a constructive action appeal, you know that up until, well, at least since 1989, up until this year, you could not settle before the board for enforcement a case in which the board had not determined that it has jurisdiction. This case finally overrules that, and so even in those cases where parties wanted to settle, they couldn't. Now they can. And it's very helpful because cases like IRA's are extremely complex, and the jurisdictional test can be complete. It can be complex as well and take an awful lot of work to prove just jurisdiction. And of course, you have to go through the hearing process. And by that point, you've heard all the evidence, so why would the parties want to settle? And of course, in a constructive suspension, it's pretty much true that if you have proven your case, that is, proven jurisdiction, you win the case because the agency didn't give you procedures. And if you don't prove jurisdiction, the case gets dismissed. So there was no point in settling the case. DeLorme finally is a case that therefore does away with that requirement. Due process is always a big issue. This is the latest court decision, Federal Circuit decision. It was made indeed in a case that involved an arbitration, not a board decision, but because the court applies the same law to the board as to the Federal Circuit, as to an arbitration decision, which is basically board law. this applies to the board's cases as well. The facts of this case were that the employee did something that appeared to be inappropriate. Her supervisor sent a note to her own supervisor saying, here's what happened. And the supervisor's supervisor saw it and said, that is the appellant's third-level supervisor, and said, this is terrible, we have to do something about it. We need to try and terminate her, meaning the appellant, for repeated use of corporal punishment and for insubordination. Ultimately, of course, the action was proposed by the appellant's direct supervisor. It was decided by the appellant's second-level supervisor. Nobody on the appellant's side at least knew about that remark, and when it came up at the hearing, the arbitrator said, okay, let's explore the issue, heard a lot of evidence about it, and ultimately determined that there was no due process violation. And a question here that you can think about here is, did the court agree? Was there a due process violation or not? Applying the Stone factors, the Ward factors, all of those that you've seen before. Well, the answer is no, the court didn't agree. It found a due process violation, but it did so by majority vote only, meaning 2 out of the 3 court members of the panel agreed. What they found was that the employee, the remark was of the type that would pretty much prejudice any decision maker, because after all, it was their supervisor who had made it. And that led the court to decide, applying the Stone factors, that yes, indeed, this was a due process violation. Interestingly, they said, just because you heard the issue at a hearing after the action was already taken, that doesn't decide anything. But the interesting part of this was the dissent. It said that this kind of a decision has the real potential to chill necessary discussions between agency officials. I mean, think about it. If you are a supervisor and you want to fire one of your employees, are you going to go ahead and do it and then say, oh yeah, boss, by the way, I just fired somebody? Or are you going to talk to them beforehand and say, should we fire her or should we not? You know, the answer is pretty clear, but then you end up with perhaps a due process violation. USERRA and VIOA cases, again, these are not ones that I'd want to go into a lot of specifics on. The point of Montgomery here really is that it may appear from board law that when you transfer an employee to a position, it isn't necessary to give veterans the right to compete under VIOA. But what the board said in Montgomery is that is only true if you're transferring one of your own employees into the position, because you have the right as a veteran to apply for any position, to be considered for any position, where the agency is accepting applications from outside of its workforce. Therefore, the case is a good one to read when you're looking at clarifying the transfer authority. The Gooden case stands for the proposition that although the agency in this case, the Army, asked for a passover of the appellant, they were denied. They then offered the appellant a job and ultimately withdrew the offer because he didn't comply with their request for documentation to prove his qualifications. The bottom line of this case was, just because you've gotten a passover denied, that does not mean that you're not subject to the same rules that apply to everybody. And here, one of those rules was that you had to prove that you were entitled to to the job, that you were qualified by showing that, complying with the agency's requirements. The Weed case is the case that talks about what the corrective action is in under 3335 U.S.C. 3330, the VOA statute. What it says is that if you win on the merits, you're entitled as a remedy to reimbursement of any loss of wages or benefits. And as you heard me say a couple of times before, the court has decided on a couple of occasions that or means or. However, in this case, the board decided that or means and. It's kind of a weird analysis, but it makes sense. Really, the board decided, well, clearly this statute was a remedial statute intended to help an employee, and it's foolish to think that Congress only wanted them to get benefits or only wanted them to get wages. They really wanted them to get both. I'm not sure whether all of these cases illustrate the reason that we need lawyers, to try and figure out these ambiguities, or whether the fact that we have lawyers is reason that we have all these ambiguities. But whatever it is, that's the rule for purposes of the Weed case. The final VOA case is the Wilson case. What the court did here is adopt for purposes of USERA, I'm sorry, it's a USERA case, the same rule that applies to discrimination in connection with the loss of a security clearance. We've said we will not look at an issue of discrimination because we can't look at the merits of the case. And in Wilson, the court simply applied that rule to USERA. So we also cannot look at a claim that taking away the employee's security clearance violated USERA. Discrimination, there really was not very much law now this past year, except in connection with the board's decision in the case of Savage versus Department of the Army, which was last year's big case. And they're really, these cases just sort of do a riff on those cases, on Savage, and explain one or another point in those cases. The biggest of the three is the last, that Hess case. The question had been raised whether, because Savage said we don't get our authority to enforce Title VII through Title VII, but rather through civil service law, did we still have the authority to issue an award of compensatory damages? And here the board said, yes, we did, and we still do. And then the final slide on the merits is just this one, which talks about a bunch of different issues. Really, each case is pretty specific to an area of law. If you're looking for attorney fees, what the rule is as to an award to a pro bono attorney, an attorney who is not charging the employee. Rumsey is your case. Little versus the Postal Service is the case that addresses the board's new regulation on whether if a decision comes to your post office box and you simply don't pick it up. It used to be under the old regs that the court construed that as not being, that you did not get it until you actually picked it up. In this case, they said, where the board pointed to its regs and said that's no longer true. McCarthy deals with whether a board's letter of declining to reconsider a decision is appealable to the court, and the court said yes, it is. And the last one just talks about the rules for timeliness in going to the court being jurisdictional, cannot be waived, cannot be equitably told, and that's about it. If there are any questions, I recognize we're right up against 3 o'clock. I'm happy to answer them now, or you're welcome to send them in to OPM, and I'll try and answer them later.
Wonderful. We might take you up on that offer to do some offline question answering, but we do have one quick question thought you might be able to address. It's a general question regarding Douglas factor number 3, which of course is the employee's past disciplinary record. Must any prior discipline be for same or similar misconduct in order for a current disciplinary action to be considered an aggravating factor?
Okay. The question is whether prior discipline has to be for the same kind of misconduct in order to be considered under Douglas, and the answer is a resounding no, it does not. The fact that you have committed the same kind of misconduct a second time will be considered in determining the strength of that factor in determining the penalty, but there's absolutely no requirement that it be the same in order to be considered. And I guess that's it. So I thank you very much for your attention and hope this has been helpful.
Mr. Bogdano, on behalf of Partnership and Labor Relations, thank you very much for sharing your expertise during today's roundtable on MSPB Case Law Update, Lessons Learned from the Most Influential Decisions. Your presentation provided an outstanding and in-depth overview of the MSPB and current case law. I thank OPM's communications staff as well for your webcast of this roundtable, and thanks to my colleagues in Partnership and Labor Relations for your work jointly on this roundtable. Thank you for participating today, and we look forward to having you at our next Employee and Labor Relations Roundtable. Please remember that shortly you will receive an email with a hyperlink to an online evaluation form courtesy of surveymonkey.com. Your feedback helps us to plan future roundtables, and we appreciate you taking the time to complete this survey. Have a great afternoon.